Luna is a professor at Cornell Law School. He's also director of Cornell's Institute for African Development. He was legal officer in the International Trade Law branch of the UN Commission on International Trade Law from 1986 to 1995. Subsequently, he served as political and legal advisor with the UN Observer Mission in South Africa, 1992 to 94. It really was one of the just handful of UN people when they were negotiating an end to apartheid in South Africa. He was then legal advisor to the UN mission to East Timor, the mission to Kosovo, to Afghanistan. He's been consultant to the Kenya's 2010 constitutional process, Zimbabwe, various things. So he's truly someone who is an academic, but also someone who's really a world citizen. And I frankly have to say I'm thrilled to get him here. He has contributed more to world peace than anyone I know. And I always keep watching the New York Times, thinking I'm going to see Muna was named as the next Secretary General of the UN, which would probably be very, very appropriate. He's really been on these various missions incredibly courageous in going into countries that really are in the midst or just getting past the civil war, and negotiating, working, and really being central to their peace process. So he's had a lot of exposure to various things, his international trade, among various things Mona has done, and I'm really delighted to have him here to be our keynote.
Thank you very much, Dean Simpson, for that very, very kind and generous introduction. I'm delighted to be here. I'd like also to thank the Law Review Committee, Law Review Group that has organized this superb conference. Jennifer, Robert, and John have really been incredibly efficient and also really great hosts for us here. I'd also like to thank Mark Jones, who's the faculty advisor to the law review, and he also has, as we all know, contributed greatly to the organization of this conference. Now, what I'm going to try and do is try and talk about the other processes that are going on in the area of international world trade, and focus on trade law, because I think that as we were told this morning, the aim in the WTO is, of course, to create an open, equitable, rule-based, predictable, and non-discriminatory multilateral trading and financial system. And I think that's the objective, and they've been striving to achieve this for many years. But of course, today we have the Doha rounds going on. But in addition to that process, we need to look at the laws, another process that's going on to complement this work that goes on at the WTO. And this is the work that focuses on removing legal obstacles to international trade. And also, after that, briefly touch on the same kind of process, but then at a national level in terms of the bilateral investment treaty programs that are going on. And both these programs are designed to really remove legal obstacles to trade. I mean, we heard this morning about programs relating to security, programs relating to corruption and all that. But I think one of the major obstacles to trade is one that is identified in terms of the uncertainty in terms of the legal system. That if you have a very uncertain legal system in the world, it will in fact hinder the growth of international trade. And here, there is an organization that does incredible work in this field that I'm sure many of you might not have heard of, but know its progress very well. And here, I'm referring to UNCITRAL, the UN Commission on International Trade Law. The UNCITRAL was created in 1966. Basically, as in this, the proposal to create UNCITRAL in the General Assembly was initiated by Czechoslovakia, but very strongly backed by the United States. So UNCITRAL is based in Vienna, Austria, and they have, in fact, as the main task to identify legal obstacles to trade, and also then work instruments that remove those obstacles in order to facilitate the flow of trade between countries. So their work is very significant, and it complements the work that actually WTO does. To this end, and I'll mention a few of the instruments that they have developed, and also talk about the way that they do this. Now, some of the instruments that UNCITRAL has come up with is, for example, the Convention on the Recognition and Enforcement of Foreign Arbitral Awards. This is a major problem in the world in terms of enforcing judgments. Many people, of course, who practice domestically, you tend to think that judgments are easy to enforce, but in fact, judgments are territorial. It's very difficult to enforce a judgment outside your own jurisdiction. In the absence of a convention, you cannot actually. You cannot take a US judgment and go and enforce it in Germany or go and enforce it in Mexico or whatever. You have to be able to operate within the context of an instrument that has been put in place. And as a result of the work of UNCITRAL, if you look at the Convention on Foreign Recognition and the enforcement of foreign arbitral awards, it is much easier today to enforce an arbitral award than it is to enforce a court judgment. What he does in this convention, which has now been ratified by well over 180 countries, is that it provides a mechanism where countries have agreed that you can take a judgment, an arbitral award judgment, and go to a country and enforce it, and that country, if it's a member of the convention, has to enforce that judgment as if it was a court judgment in their own country. Very, very significant work and a tremendous achievement. I mean, we could go on to discuss in terms of the conditions of what you do and how this works, but I think it is for this, for this audience, it's sufficient to identify this instrument and look at the significant work that it has done. I also mentioned the work that has been done with respect to arbitration. Today, the world arbitration scene is very well organized, largely because of UNCITRAL. Not only have they worked on the enforcement of arbitral awards, but they've also come out with the UNCITRAL model law on arbitration. When this work was being done, they debated whether to have a convention or to have a model law, and many argue that the model law would not really resolve the diverse approaches to arbitration in different legal systems. But in the end, in fact, the UNCITRAL model law today is one of the most widely implemented pieces of legislation. If you go to Canada today, the arbitration laws in Canada are exactly the same as in Australia, and that's because of UNCITRAL, because that's the model law that UNCITRAL developed. can appear as an UNCTAD document, but actually, if you look at it, it's clause by clause the same. And you go to India, it's the same. They've adopted the arbitration laws from UNCTAD, so it's a worldwide movement. And that has created a very unified process of dealing with arbitration. In addition, and if you look at even when companies have arbitration clauses in their contracts, you'll see that very often they refer to the law as the UNCTAD model, UNCTAD arbitration law. So, and UNCTAD has also done a lot of work in the area of sales contracts. It is very easy, of course, to enforce a sales contract domestically. But the problem, of course, that also identified is that when you have a contractors dealing with two different things, you have an international contract. And then you have a problem in terms of what law applies to that contract. Now, traditionally, the way you approach that field is actually to use, Dean Simpson's expertise in order to go to conflict of laws, to kind of resolve what law is going to be. But that meant that at any one time, you weren't sure what law is going to apply. It was unpredictable. It could turn out to be your own country's law. It could also turn out to be another country's law, because it's all dependent on the court. And that, of course, was perceived to be discouraging a lot of international trade. So what has happened is that UNCTAD in 1980 concluded a convention, which is called the UN Convention on Contracts for the International Sale of Goods. And this convention is very, very widely accepted and acceded. The United States is a party to this convention. And in the US today, as a result, in sales contracts, you actually don't need the assistance of conflict of law rules, because the law is definite when, in fact, you have an international contract. You no longer need to go to conflict of law rules to determine what law is going to apply to that. And if you look at the sales convention, you will find that it's very, very widely accepted. It is now, has, again, just like the arbitration, the enforcement convention, somewhere around 180 states are part of that. And many states have actually enacted this convention into their own domestic law. And in fact, if you look at the way the convention is structured, you'll find that even in cases where the country is not party to the convention, it could be the law. Because if the law, for example, if there's a contract that involves an American and somebody else, and the court determines that the applicable law in terms of using conflict law rules is American law, that's going to be the sales convention. Because the US has a state sales convention. So you can see the significance of it, and it has in fact replaced the need for use of conflict law rules in the context of sales contract. For just, we don't have too much time, but I will go on and on to mention many, many other significant laws that I would invite students who are interested in trade law to investigate and study and do research in this area. There are instruments in the area of the limitation conventions, in terms of limitation, the time. Because it's one of the problems in international trade is that you go to a country and you're trying to sue, and you find that there's a different limitation period from your own. The time has expired. So of course, again, there, UNCTAD has come out with a convention which is called the Convention on the Limitation Period in International Sale of Goods. And it imposes a uniform limit when the contract involved is an international contract. So that you don't have to worry about that, about what India says and what Australia says. You can actually deal with that in that way. They've also done work in the area of security interests. There is a convention again in that area. They also have a convention with respect to payments and insolvency, bankruptcy, because there are international aspects of bankruptcy. Sometimes you are pursuing a company here, but in fact some of its assets are somewhere else. And there are cross-border issues in terms of how you're going to deal with it. And again, that's an area where a convention has come up. And I know there are several other areas, but I think I should try and move to the second process that I wanted to bring your attention to. And this is the bilateral investment treaties. These are also a significant process that's going on to complement the work of UNCITRAL, and also to actually create substantive law which is useful, and also to create ways and means of determining what forum you can go to in terms of a dispute. So what's going on here? So with the BITs, they're recent phenomenon. In fact, the first BIT was signed by the Germans with Pakistan in 1958. That was the first BIT. One could argue, of course, that there is an ancestor to the BITs, which is the Friendship and Navigation Treaties that used to go on. But I think that most would agree that this recent process is more really from 1958 with the Germans. Today, this process has grown so much that we have well over 2,500 bilateral investment treaties. And if you go to the US website, the Commerce Department, you see that they're committed to concluding BITs with every country if it's possible. So you ask yourself, what's this about then? Why is it that countries consider this to be important? What is the role that BITs play in this process? Now, basically, traditionally, the way you sought protection outside your own country is through international law. But unlike local laws on, say, foreign investment, which can be adequate for protection, the advantage between being protected under an international instrument and over a local instrument is, of course, the issue that we discussed in terms of extraterritorial application, but also no state can unilaterally change international law or a treaty that it has entered into. And of course, there are many, many gaps in the international law system. As a result, the BIT has come in to fill that those gaps. So what you actually get in these BITs. So, for example, the US has BITs with a lot of the Latin American states, the BITs with Eastern Europe states. What do you find in these treaties? You find that basically they try to address issues which will increase the protection of American investments abroad. So one of the things they deal with is, of course, how you define investment. But what is an investment? And that's, of course, an attempt to broaden the term to cover many types of things that happen. Because the traditional definition of investment is really like, building a factory and that sort of thing. And many excluded portfolio investment. So the result is that with this instrument, you can actually be very broad. And then, of course, they deal with questions of admission, and then, of course, the treatment of investors, which, again, this morning was the subject of discussion. So they will deal with the fair and equitable treatment of investors. And they deal with the question of expropriation. And here, it's very important because you would want to be protected in terms of the standard. You don't want a foreign corporation to be treated in the same way that a local corporation is treated in terms of issues like compensation in the event of expropriation. So what they do is, of course, that the BITs end up creating what you might call lex specialis between the two states. That you create a special law that actually applies to investors from both sides, between the two countries that are parties. So the US is party to a BIT, will say, Uruguay, the law, the substantive law that they have to use will be the law that is actually in the BITs. So, now of course, the BITs are premised on the assumption that they increase and promote investment, because of course they kind of remove the obstacles that are in the way of investment. they outline standards which attract investment, so that you remove the fears in relation to how you are going to be treated. There is also a very important aspect of the BITs in the sense that we heard, for example, about risks, that in many cases they do deal with questions of insurance of firms. Because if for example, you're going to insure an American corporation in Chile, of course you're worried in terms of what happens when in fact the company is mistreated. So the BITs, the US for example, has a condition that when you can use OPIC insurance, but only in states where there's a BIT. Because of course, that way the US is able to enforce the conditions that are contained in the BIT in terms of course of subrogating in the event that they have to pay the insurance. So quickly, one of the other important aspects of the BIT is of course dispute settlement. That a major problem that companies worry about is of course how you're going to settle disputes when something happens to you in the country where you've gone to. So you will see that in a lot of the BITs there is provision that in the event of a dispute there will be arbitration. Because one of the major problems of you, first of all, companies don't want to go to local courts because they perceive bias. And very often also you run against issues relating to immunity and that sort of thing. So a major feature of the modern BIT is to allow foreign investors to access international investment tribunals. So you'll find that in all the BITs that the US signs, they have provisions which require access to arbitration. And that is, for example, the preferred center, of course, is ICSID, which is the International Center for the Settlement of Investment Disputes, which is created under a convention and has its headquarters in Washington, D.C. But it's an organization that was, in its creation, spearheaded by the World Bank and the IMF. So before the establishment of institutions like ICSID, you had to rely on a spousal. If you had a problem internationally, you had to go to your country, your state, to take up your case for you. With ICSID, you don't have to do that, because with ICSID, states have waived that, and companies today, because of this instrument, are able to go on their own directly to pursue a state that has taken over their assets or has behaved in a manner in which they violated a contract. So you see that it's a very, very significant achievement in terms of dispute settlement. It also, of course, does determine questions of the applicable law, what law is going to apply in the context if there is a dispute. So those are some of the features that one sees in the context of this BIT movement. As I was saying, it become a big and major project. There are today, as I said, over 2,500 of these BITs. And if you go to the US website, the Commons website, you will see that they are committed to conclude more and more BITs. Now, there are, of course, problems with respect to some of what we see as a backlash to what has been happening in the BITs. So it has done this, but recently, of course, some of the countries have begun, especially developing states, they began to complain that the BITs are limiting the freedom of action by states in economic matters. So this is one thing that, of course, we have to observe how it develops and what impact it's going to have on this process of BITs. Now, I think one of the countries that has had this experience and has complained most about it is, of course, Argentina, following the crisis that it had. Argentina today has, I think, in ICSID, well over 80 cases against it. Many of those cases would not have been possible. They are mostly by US corporations. They would not have been possible in the absence of ICSID. And there's one case, MS Gas Transmission Company based in the Republic of Argentina, which went against Argentina. And Argentina, after that, began saying that it's thinking about actually withdrawing from the process. They've also had sort of a backlash from countries like South Africa, which have argued that South Africa has in fact now suspended any negotiation of BITs because it lost a case against Italy in ICSID, which was brought by Italian firms that objected to South African laws relating to affirmative action. And they say that it was an interference in their business operations, and they won the case in ICSID. And South Africa feels that they have to really examine the whole process because it is now preventing them to transform the society in which, because of the legacy of apartheid. But I wanted to bring this out to, as areas of tension, to see that although one can paint a rosy picture in terms of what the BITs are achieving, but you can also see that as the system is operating, we're beginning to get some kind of backlash, and one cannot tell where exactly we will end up. But I think just to end my remarks on the BIT is to emphasize the point that they do serve a very, very important function in the context of international trade, because they address issues of the treatment of foreign firms in jurisdictions which are party to the BITs. They fill the gaps that exist because of international law. One of which, for example, is the question of the nationality of a corporation. Because under international law, the nationality of a corporation is always the national jurisdiction, and that's the Barcelona traction case. The ICJ ruled that, in fact, the nationality of a corporation is local because there is no international corporation law. It's always domestic. Now, of course, that's problematic for a corporation that operates outside because you don't want to be treated as a local in a lot of situations. And what you do in the BITs is you address that issue, for example, so that, in fact, corporations are deemed to be foreign if this and this happens, or whatever, if there is this kind of shareholding. And you can see the significance of what these instruments achieve. So, I think just to conclude, I would say that, as the world economy is expanding and getting more globalized, I think we are going to see more and more instruments that try to address issues which remove obstacles to international trade. And as we consider the question of the work of WTO, we should also realize that there is this other process going on, which is working hand in hand with the WTO, which of course focuses more on tariffs and that kind of thing. But you actually do have a very significant process going on. And I mentioned UNCITRAL, but one could also mention the fact that you have UNITRA, which is based in Rome, which is older than UNCITRAL, which was doing some of this work before. But the US felt that the UNITRA was really very European, and that UNCITRAL is a much better forum because it's the worldwide movement. And you do also have the Hague Conference in The Hague, which also has been working in that area. But I think the lead organization in this field is actually UNCITRAL. So I think I'll end there with those remarks, and we can have a discussion. Thank you.
Professor Ndulo will be in the final panel, so you can address questions to him at that point. That'll probably be around 4:30 or so, but he will be back at that juncture. But thanks very much, and I guess Jennifer's Going to tell us to head to the bus?
Yes. Just as kind of a general